Lordship's indulgence in mentioning part 2, item number 1 and 6, my lord.
Yes.
My lord, this matter is taken up by Miss Mary, and she has some personal difficulties this week, my lord. If this
Okay,
matter may
so-
be taken up next week.
Have you informed the other side?
Yes, my lord.
Yes, Your Lordship, we have no objections regarding that.
Okay.
And Your Lordship, if the matter be listed on this next week, Thursday,
Thursday may not be
Possible.
possible. We
Okay.
listed the week thereafter. Today is what? Today is 5th.
this is the 25th.
We'll have it on the hearing, on the weekly hearing list, commencing from 16th of June. All right.
Yes, my lord.
Ms. Mary L. Kiamte, learned government advocate, is said to have some personal difficulties to conduct the case. On a prayer made on her behalf and not objected to by the other side, matter stands adjourned to be listed again in the weekly hearing list commencing from 16th of June.
My lord,
Item 1 and item 6.
Yeah, my lord.
Part 2, items 7 and 8. These matters may kindly come up next week on Tuesday. This is regarding claim of the petitioners for regularization. They are contract employees working under Ripans.
News for the other side.
Mr. B. Enger is there, Your Worship, and he had requested me that since he'll be out of station today, if they can come up next week, Tuesday.
Okay, as paid for on behalf of Mr. B. Ramenga, learned counsel for the respondent number 4, and not objected to by the other side. List the matter on 10th of June,
I'm obliged.
7 and 8.
May it please your Lordship.
Yes.
Lordship, we filed a writ petition yesterday, my lord. The matter pertains to non-payment of the statutory compensation under Section 80. My lord, if it is not inconvenient, could it be taken up tomorrow, my? It was filed yesterday, my.
Okay.
My. Deeply.
Motion, item 1.
Lordship, in this criminal petition under section 528 BNSS, which is a replacement of section 482 CRPC. The applicant is seeking for direction of this honorable court, directing the respondents to release the cash amounting to rupees 1,03,97,500 illegally detained in the bank account of the respondent number 7. Respondent number 7, Lordship, is the Principal Director of Income Tax Investigation, NER, Goti. And the said cash being the sale proceeds in respect of the properties, the articles, consumer goods of the applicant, and which has been carried by those 3 persons to be deposited to the applicant. It was intercepted by the Assam Rifles, and then having had the suspicion that the money could be something connected with some contrabands. So they had seized the said cash from the 3 accused persons who were produced before the court of CJM at Champai. And Lordship, a perusal of the annexures will indicate at page 26, annexure 3, the Lordship will see this is a letter from Nalan Police Beat Post, SI Nalram Chulova, to whom the said cash was handed over by the Assam Rifles. And here This is a letter from the said ASI addressed to the Chief Judicial Magistrate, Champhai District, through PI Champhai Court. And here it says, I am forwarding herewith below noted persons who were arrested on 22nd to 2024 in connection with the above noted case. The accused persons were apprehended and seized a cash rupees 1 crore 3,97,500 from their possession by Nalan Police and Second Assam Rifles, Nalan Post. They are needed for more interrogation and needed to remand under police custody. I therefore pray that they may kindly be remanded in police custody for a period of 48 hours for more interrogation. And the names of those persons are listed here, 1, 2, 3. And at page 27, there's another letter dated 24 to 2024. This is also a letter addressed to the Chief Judicial Magistrate for wording of suspected individual for discharge. After thorough investigation having had upon those arrested persons, the police officer in charge, Nalan Police Beat Post, had asked for discharge of those 3 persons, in which he had stated, I am forwarding herewith the below noted individuals who were caught carrying unaccounted cash amounting rupees so and so as per your order, dated 23 to 2024. They have been under police remand for the last 24 hours. The below noted persons have been thoroughly questioned during the remand. However, it's learned that majority of the money belongs to one Lalshia Zavi, daughter of Lalom Zwala of Zaukothar, who is the applicant here, the petitioner here. And involvement of the 3 individuals is on smuggling of contraband items could not be established so far. Hence, they may kindly be discharged on the condition that they will make themselves available as and when needed for investigation. So, on the basis of the said request made by the officer in charge of Nalan Police Beat Post, the said 3 persons forwarded to the court were discharged. And at the same time, the information was also given by the same officer, white letter dated 2023 to 2024 at page 28 in Lordship. This is regarding on the subject of intimation of seizure of money under section 100 of CRPC. It is stated, I have the honor to state that in the morning of 22nd February 2024, information is received from personnel of Second Assam Rifles, COB Nalan, that 3 individuals, most likely Myanmar nationals, were apprehended with large sum of money, approximately around 1 crore. Hence, police are requested to take necessary action. Accordingly, ASI Laram Chullava proceeded to the PO, since the said 3 individuals could not explain their source of income and only stated that the money was to be handed over to one named Mapui of Zaukothar without disclosing the source of money. Since such a large sum of money was found near the border and the source of money was not explained properly, the money was seized under section 102 of CRPC, as the money could be used for some smuggling of contraband items and smuggling items. The money, along with the 3 individuals, were brought at the Champhai police station. Money was counted and total amount of cash seized was 1 crore 3,97,500. The money was kept at Champhai PS Malkhana for safe custody, white number so and so. Money will be handed over to concerned department, either Income Tax Department or Enforcement Directorate, since they are concerned agency for dealing unaccounted money. However, preliminary inquiry is being conducted, and which agency the money will be handed over to will only be decided once the source of money is established after preliminary inquiry submitted for your kind information. And In this connection, money was not produced. Only those persons were produced before the before the Court of Chief Judicial Magistrate at Champhai, and they had the police had taken care of the said cash and kept the same in their own custody at Malkhana, Police Malkhana. And in the meantime, an application under Section 451 read with 457 of CRPC for release of cash mounting to rupees so and so on Zimanama to the applicant was submitted by the applicant before the Champhai Chief Judicial Magistrate at Champhai. And this application was considered and rejected. Lordship, the letter by which, the order by which the application was rejected is at page 52.
Yes, I've seen it, Mr. Ramzawa.
Lordship,
Money was seized from 3 persons.
from 3 persons.
And who is the petitioner in this case now?
Petitioner is Lalshil Zawi.
I know. How do you say that this is your money? Money is not seized from you.
It's not seized from us,
Then
from the applicant, and this is the money of the applicant,
how do you know?
which even those 3 persons have stated that it is to be handed over to the applicant. And
Why were they carrying so much money with them? What is the
Your Lordship-
explanation?
Your Lordship,
What is the explanation?
the
These 3
explanation,
persons are foreign nationals.
they it appears that they are foreign nationals.
So why are they getting so much money? For
They
what
have
purpose?
brought that money, being the sale proceeds in respect of those consumer items.
Like what?
Lordship,
You have annexed some receipts. I don't know. I can't read the receipts. What does it mean? You can't
Yes.
understand this.
these are the receipts in respect of the transaction.
What
from
transaction?
RL store, Pulikon.
Okay, what is the transaction? What are the goods? Or what are the commodity?
Commodity is not.
Cash transaction or what?
No, it's not. It's not cash transaction. Sometimes the transaction has indicated that it is a payment of cash back to the proprietor of RL store. And here some maida and chini
Where is that? Maida.
at page 32. Lordship will see.
1 crore rupees for Maida.
No, not 1
And
crore.
chini.
And here, this sequence of cash memos, starting from page 29.
So what is the explanation of this cash memo? What does it mean? It just gives them figures. We don't know what is the commodity.
Lordship, commodity has not been properly or in
Then?
detail written, but here Lordship may see, page 40. Page 40. This is an affidavit duly shown by the owner of RL store, who had issued all those cash memos. Here, Your Lordship, may I read?
I've read it. Doesn't say anything.
Yes. But
What
it
did
says,
the RL store supply or sell? There's nothing
what
written there.
it says,
There's nothing there.
to whom I used to send various consumer goods on credit and even on cash payment.
What are those consumer
Various
goods?
cash memos enclosed by her in connection with her claim of ownership of seized cash amounting to rupees so and so were issued from RL Store Kunikon Isaac. So the source of these cash memos being the RL Store owner has clearly explained that
Mr.
these are the
Ramzawa,
cash memos.
any case has been registered?
No case has been registered. The only thing is that it is by way of a GD entry. GD entry 433/24 dated 22 February 2024 under section 41 CRPC. That was the only thing that was registered. And since they could not establish or they could not find that it is a cash in connection with any such prohibited items or contraband, the case IO had asked for and submitted an application for release or discharge of those 3 persons. And in the meantime, Your Lordship, the manner in which the money has been handled by the authorities of the police department is not in accordance with law. What they have stated here at page 28, is that the money was kept at Champai PS Malkhana for safe custody, right number so and so. Money will be handed over to concerned department, that is either Income Tax Department or Enforcement Directorate, since they are concerned agency for dealing unaccounted money. However, preliminary inquiry is being conducted, and which agency the money will be handed over to will only be decided once the source of money is established after preliminary inquiry. And the authorities of the police at Champai, without further inquiry, they had simply handed over said cash to the Income Tax Department. Here is a letter at page 45. Page 45, letter addressed to Deputy Director, Enforcement Directorate, Aizawl Subzonal Office. This Enforcement Directorate is of Income Tax Department. May I read, Your Lordship? This is by email. On the
By this letter, it was handed over to them.
Yes, Your Lordship.
Then the money has been kept in the account of the respondent number 7.
Respondent number 7.
Now, what has happened to that GD entry? No investigation.
GD entry, since no case has been registered, it has been closed.
We'll issue notice at this stage. What can be done?
Lordship.
Third, Mr. Sheila Ramzawa, Learned Senior Counsel, assisted by Mr. Jamal Somzwala Vansal, for the petitioner, who submits that by filing this criminal petition under section 528 BNSS 2023, the petitioner seeks for a direction for release of sum of rupees 103,975,00 belonging to the petitioner, which was seized from 3 persons. By the Assam Rifles personnel on 22/2/2024. Stop the learned senior counsel submits that the said amount was supposed to be handed over to the petitioner. In connection with certain sale proceeds from RL Store, Kulikon, Aizawl. So despite the money having been handed over to the police at Champai and the police authorities contemplating inquiry into the matter, the entire amount has been handed over to respondent number 7, who has retained the same in its bank account.
Your Lordship,
Hmm?
this is without any direction from the court.
To stop the handing over the cash to the respondent number 7 is without any direction from the competent court. To stop the learned senior counsel submits that although the petitioner submitted an application for release of the amount seized by way of Zimanama by filing CMA number 5 of 2024 under section 41 CRPC, the application was dismissed by the learned Chief Judicial Magistrate Champai. Stop being aggrieved, the petitioner has filed the instant criminal petition. Next para, in view of above, issue notice of motion returnable by 4 weeks. Ms. Vanesyami, learned additional public prosecutor, accepts notice on behalf of the respondent numbers
1 to 5.
1 to 5. Stop. As such, no formal notice is required. Stop. Petitioner shall furnish requisite copies of the criminal petition to the learned government advocate, if not already done. Any standing counsel? Income tax?
Income tax,
CGC cannot appear. Ms. Zaram Sankwi, are you appearing for income tax? Petitioner to take steps for service of notice upon respondent number 6 and 7 by registered post with ADD. Within 3 days. List the matter again after 4 weeks.
hello, please.
Item 2,
petitioners. The petitioners were claiming they were contract regularized lecturer from
You're saying it's a covered case,
his minor.
but we'll issue notice. Judgment was delivered just recently. Any appeal?
Yes, Your Lordship. issue, the notice may be issued because this will have a far-reaching implications on the other.
My question is,
Yes, Your Lordship.
is there any appeal filed against that judgment?
Your Lordship, not yet.
Not yet. Which means you are intending to file. Anyway. Heard Mr. Victor L. Ralte, learned counsel for the petitioners, who submits that by filing this writ petition, the petitioners claim the benefit of counting their past services rendered on contract basis for the purpose of moving forward
To senior grade.
to the senior grade lecturer. In terms of what is the memorandum which is favorable to you?
Page 36.
In terms of the notification dated 4/12/2020, 2012. I repeat, notification dated 4/12/2012. Okay.
And page 49, the impugned order rejecting my representation. Page 49.
Stop. The learned counsel submits that although a representation was submitted by the petitioners, but the same was rejected.
Page 49, annexure 10. Referring to the OM dated 22/1/2021.
By referring to the office memorandum dated 22/1/2021.
The recent judgment is in page number 59.
Just a minute. By which the Mizoram government employees, public, open bracket, counting of past service, close bracket, rules 2020.
Stipulates to count only 1/3.
Has been made applicable to the case of the petitioners. So stop. The learned counsel submits that, in fact, this court, wide judgment and order dated 13/5/2025 in WPC number 85 of 2024 had set aside the office memorandum dated 22/1/2021, and such being the position, the petitioners cannot be deprived of the benefit given by the notification dated 4/12/2012. 4/12/2012. Okay. In view of above, issue notice of motion returnable by 4 weeks. Ms. London Louis, learned government advocate, accepts notice on behalf of all the respondents. As such, no formal notice is required. Petitioners shall, however, furnish requisite copies of the writ petition to the learned government advocate, if not already done.
I'm obliged.
Much obliged, Your Lordship.
Item 3. May I please, Your Lordship?
Yes.
Yes, in this writ petition, we are challenging the impugned order dated 10/5/2025, passed by the Lok Adalat, which is passed beyond its exercising its beyond its jurisdiction, my lord. The Lok Adalat case was withdrawn, dismissed as withdrawn by the
Withdrawn by whom? The
By
private
the-
respondent.
by the respondent number 3.
3.
But still, my lord, the impugned order is at page 10. A direction was made.
What is the arrangement between you and the private respondent?
My lord, the,
You borrowed some money,
yes, my lord,
25 lakhs
my lord,
from the private respondent.
my lord.
And what is the other condition?
And the Komatsu excavator was mortgaged,
Your excavator.
my lord.
Your
Then-
excavator was mortgaged.
My lord.
You were supposed to repay the money within 1 month
Within 1 month, as per the,
with 100% interest.
my lord.
How do you borrow money like that? 1 month you borrow the money and you promise to pay 100% interest. How can that be? Unless you have a minting machine.
Exactly, my lord. So due to the
Bank interest, what is the bank interest nowadays?
around
6%.
6% per year,
So even if you borrow money from the bank,
my lord.
you have to pay back a lot of interest.
Yes, my lord. That,
And if you deposit money also, you'll get that much interest. But here some arrangement is there between the parties. So it's quite unusual, or it's usual, whichever way. Anyway, your case is that Lok Adalat has exceeded its jurisdiction.
my lord.
What has it done?
Page 10, my lord. The official in charge of the Kulikon police station, that is the respondent number 2, was directed to detain the excavator of the instant petitioner.
Where is the excavator now?
Excavator is still in my custody at the workplace near the bank of Trong River, my lord.
Okay. And by this order, they are supposed to take the custody of that
My
excavator.
lord, my lord. See, this order is not sustainable in law. It's beyond the jurisdiction of the local delegate.
What about the civil suit? Anyone has filed any civil suit? Or money suit or whatever? You're
my
not
lord.
aware?
Not yet. I'm not aware of any such filing of civil suit.
Who are the respondents here? Home, state,
State,
OC.
1 and 2, my lord, state.
What do you say, Ms. Vanessa?
Yes, Your Lordship. Since the main respondent is not present today and he is not aware of the case also, my lord. So if notice may be issued.
Oh, that's a different thing. What I'm asking you is that can such kind of order be passed?
In my opinion, my lord, I cannot say that exactly.
You cannot say.
Yes, that's,
What is the Lok Adalat supposed to do? Decide cases?
no, my lord.
Then can they pass direction? Do this, don't do that. Unless the parties agree, they come to a consensus, then they just record, they can perhaps
Exactly.
give some sort of a counseling for the parties to agree. Well and good. We'll have to issue notice at this stage.
And my lord, the operation of the impugned order may be stayed.
Then what remains?
Because, my lord, the respondent number 2 is still mounting pressure on the petitioner, and he even warned him of arrest on last Saturday, my lord.
Okay, this side heard Mr. Lalsan Kyangte, learned counsel for the petitioner who submits that by filing this writ petition, the petitioner has challenged the order dated 10/5/2025 passed by the Lok Adalat. In Lok Adalat within bracket PRE case number 114 of 2025. First of the learned counsel submits that a complaint had been submitted by the respondent number 3 before the Lok Adalat, but subsequently he withdrew the same. First despite the withdrawal of the complaint, the Lok Adalat proceeded to pass the impugn order, which in fact is beyond its jurisdiction. To stop referring to the impugn order, the learned counsel submits that the respondent number 2 has been directed to detain the Komatsu hydraulic excavator model number PC 210-10 MO M/C/ serial number N730953 in safe and proper custody, pending order to be passed by a civil court having jurisdiction. The excavator, it does not have a registration plate or something.
My lord, no registration like other vehicles.
Then how do they? This is a model number.
My lord,
Then what is this MC serial number? This is what engine number, chassis number.
serial number is the. My lord, there is no mention about the engine number.
Does it not have a registration plate?
No,
kind
no,
of-
my lord.
they don't have.
These are not registered. This.
Not yet
machines,
registered, or they are not registered.
They never registered, my lord. As far as my knowledge is concerned.
Next para, in view of above, issue notice of motion returnable by 3 weeks. Ms. Vanessiami, learned government advocate, accepts notice on behalf of both the respondents,
1 and 2.
respondent numbers 1 and 2. Petitioner to take steps for a service of notice upon respondent number 3 by registered post with ADDU within 3 days. List the matter again after 3 weeks. Stop in the interim. Cancel that. Having regard to the projection made by the petitioner, it is in the interim, the impugn order dated 10/5/2025 passed by the Lok Adalat in Lok Adalat bracket pre-case number 114 of 2025 shall remain state till the next returnable date.
And my lord, the respondent number 2 may be directed not to make any harassment.
Where's your prayer?
Yeah, it's at page number 8, my lord. Respondent number 2, actually, my lord, he called the petitioner to come to the police station and he warned him of arrest, and he said that he will be sending him to jail on that Saturday unless he sign an undertaking, which is at page 14. My lord, my lord. My lord. Oblige, your lordship.
Admission item 4 to 6.
Lordship, this matter has been fixed at the instance of the counsel for the respondent number 7. Who respondent 5 to 7. Priyangshu Goswami has represented the respondents number 5 to 7.
Lordship, Priyangshu Goswami has requested me to make a mention on his behalf that he has some difficulty to appear today, and similar type of cases in which acquisition matter is relating has been fixed on 2nd of July, which I have mentioned on Monday. So it may, he requested me to keep it on the next day so that.
What is the matter regarding?
It's regarding the non-payment of the awarded amount of compensation in respect of the border road fencing. In connection with award number 5 of 2009.
So what is to be done?
Now that he's expressing difficulties again, the Lordship is of the view that his application, his request may be considered.
2nd of July.
Yes, and it may be fixed on 3rd of July in that case for these two items.
3rd of July.
Yes.
Mr. Ramzawa, we'll fix it then.
All right.
Mr. What is his name? P. Goswami.
P. Goswami, yes.
Mr. P. Goswami, learned counsel appearing for respondent numbers
5 to 7.
5 to 7. He said to have some personal difficulties to appear before the court today on a prayer made on his behalf and not objected to by the other side. That's the matter on 3rd of July.
And all that.
Items 7 and 8.
Lordship, these two items in respect of the promotion of the promotion case under the Apex Bank. Lordship, these two cases have been clubbed together because they are of analogous matters. And it may be fixed on next week, sometime next week, as a Lordship may find it convenient for final disposal.
No objection, my lord.
Did it come up week after that? 16 of June,
16
Monday.
times.
Usually Monday is free. You should take chance on
Oh.
Monday.
Well, Lordship will be there.
I don't know. I'm not sure. Doesn't have to be. Anybody can be there. As paid for by the parties, list the matter on 15th of June for admission hearing.
16. Obliged.
Item 9.
First time.
First time. Yes.
What is this? MAC appeal.
Mac appeal, yes.
Any delay?
No delay.
Have you deposited the money?
25,000.
25,000.
Yes.
Why have you filed this appeal?
The appeal is filed basically only on one ground, saying that the driver of the vehicle was not the owner, and the owner of the vehicle is one Samuel, and the vehicle was driven by one Mai Singh, who fell down, fell on the gorge, and he died on the said vehicle. Now, the argument is that the driver of the vehicle, not being the owner, he cannot be paid the rupees 2 lakhs, which is entitled by the owner cum driver, personal accident claim.
How much is awarded?
2 lakhs.
For injury?
No. For the death, in respect of owner driver package.
Who driver died?
Driver died, but he was not the owner cum driver in that case. So this case is squarely covered by one of the judgment of the Supreme Court, Guwahati High Court, which says that if he is not the owner of the vehicle, other person driving it, he steps into the shoes of the owner, and he is not entitled to claim for any compensation.
So what is the arrangement like that if the owner is the driver, he will get 2 lakhs?
He can approach other forum, not the third party claims tribunal. That is the findings and understanding.
So he has claimed under what provision of law?
163A of
163A.
3A.
That is
Before the
governed by,
MSET.
that is governed by certain notification.
Yes,
Where is the notification? Let us,
he has claimed under 163A for in the MSCT tribunal.
163A is only, it's in the tribunal only,
Yes,
on no fault basis.
no fault basis. But
So
argument is that he,
that no fault formula
Huh.
is done away with now.
yes,
There's
because
a notification, isn't it?
Yes.
Government opinion of notification.
yes, and after that it has been amended by 164.
164.
Yes.
So which one will apply? The amendment.
Yes, because this is a case of 2021.
So
And-
before the amendment.
Yes,
So it will be covered by that notification. Or what?
yes, yes.
Where is the notification? How does it say? What does it say?
Notification is not,
Is it discussed anywhere here in the
not
judgment?
discussed about the notification.
No, I
Only
just wanted
discussed
to know the
on-
formula. What kind of formula do
Only,
you apply?
discussed only on the basis that he is the driver of the vehicle and he steps into the shoes of the owner and he is entitled for payment of rupees 2 lakhs. But that understanding is wrong as per the judgment of the Guwahati High Court.
No, leave out the judgment first.
Yes, yes.
First of all, you just tell me this 2 lakhs is calculated on what basis?
2 lakhs. Personal accident cases, owner cum driver is entitled to rupees 2 lakhs if he meet with an accident without any other involving any other vehicle.
Says who? There's a policy in that.
Yes, PA
Where's the
cooperates.
policy? Show me. If the owner cum driver meets with an accident and he expires, he'll be entitled to rupees 2 lakhs. That is what the policy says. Correct?
Yes,
And you're saying that the person who drove the vehicle is not the owner.
yes.
Then
Yes, there are-
what
it
is the necessity of filing 163A then? If the policy itself is there, isn't it?
Yes.
They will come and file an application with the death certificate and the insurance company should
Yeah.
give the money, that's all.
In that case, they have to approach the
Why,
company.
why do you have to go to the tribunal?
Yes,
Since you already have a policy
yes, yes,
saying that
yes,
you are covered.
yes,
You are the owner, if you meet an accident,
yes.
unfortunately, if you expire, you will be, or your legal heir will be entitled to rupees 2 lakhs. So, person expires because of use of the vehicle, and he's the owner. Then he'll make one application and go to the insurance company and say that this is a death certificate, give me. They should give him. But instead now what they do is they go to the tribunal.
Yes.
Notice goes, insurance company will say that we'll think about it. Let us see. Let me file my WS.
Yes.
And after few years, then they'll give the money.
And in this case, we say there is no jurisdiction of the tribunal.
What was your stand before the tribunal?
Our stand is that the tribunal has got no jurisdiction to entertain this kind
Let
of.
us see from the
This is-
judgment.
Our evidence is in page,
You are OP1. OP number 1.
in the tribunal.
Yes.
Yes. Is page number 20.
20 or 16?
20.
Hmm.
Yeah, 16 is our written statement, the
Written
contents of the written
statements.
statement.
So the usual objections are there.
Yes,
Not maintainable in form and style, all that is there.
it is in one.
He was
On
only the
15th
occupant.
line. 15th line.
The claim is not maintainable.
Under 163 of the
Read-
MPA,
yes.
inasmuch as the driver of the vehicle ran off from the road and he was the only occupant, the claim is liable to be dismissed, so and so. And then in the next page, last line, from the bottom, that the deceased driver, late M.I. Singh, was a teacher by profession under the government of Mizoram and not a driver by profession. he was employed under the government of Mizoram and no master-servant relationship existed with the insured owner Samuel Aldin Lianavate. As such, the driver steps into the shoes of the owner and is not a third party. Since the deceased is not a third party, as such, the claimant is not liable to get any relief before this tribunal, and according the claim, petition needs to be dismissed. This is the stand of the company in the WS, and as well as in page number 20 or in the evidence.
Insured owner is Samuel
Yes,
Aldin.
yes.
And
The claimant
The
witness
vehicle belonged to Mr. Samuel.
Samuel,
And what was he doing driving that vehicle?
this MI Singh.
Yes.
MI Singh was driving, and the witness, the evidence of the claimant suggested that upon the consent of the owner, they were using the vehicle.
Oh, he was using the vehicle.
Yes, it is there in the evidence of the claimant witness
okay.
number 1, saying that on the consent of the owner, the husband drove the accident vehicle as allowed by the owners. It is in page number 18, that statement of the witness.
So the policy with your company is that you should be the owner come driver
Correct.
to get this benefit.
Correct.
Now, what is the finding of the tribunal and where, in which paragraph?
Page number 26,
Hmm.
paragraph number 15.
Yes.
The Honorable Guwahati High Court in the case of Thanguri versus so-and-so writ petition, which was disposed of by order dated 2/6/2020, has allowed the claim for owner cum driver to be made before the MACT. In the instant case, the OP number 2 is in their evidence has also admitted that since the deceased was the driver, he had stepped into the shoes of the owner at the time of the accident. A perusal of the insurance policy goes to show that the premium of the owner driver was paid and the liability of the OP number 2 was shown to be rupees 2 lakhs. Therefore, the issues are partly decided in favor of the claimant. The claimant shall be entitled to sum of rupees 2 lakhs.
Okay, what is this stepping in the shoes of the driver, owner?
Yes,
means?
if your lordship sees, I'll produce one, this will make easy understanding. I'll produce one judgment of the Honorable Guwahati High Court, which speaks about the shoes of the owner.
Is it this same judgment, Thanguri?
No, this is a slightly different one. Paragraph number 14, the last page. The position of the claimant is neither way beneficial for his claim. If the claimant has hired or taken the bike with the consent of the owner, he steps into the shoes of the owner and he cannot claim compensation. The stand of the claimant is that they have taken consent from the owner to drive the vehicle, and accident happened thereafter. And in this case, the same thing happened. And the finding of the High Court is that he cannot claim compensation if it is that case.
Do you have Thanguri's judgment?
At this stage, we do not have, because that is in writ petition, not in make appeal.
Okay, but the position propounded is same thing.
Hmm.
If you drive the vehicle with the consent of the other side, the owner, then you step in the shoes of the owner. This is what it says.
Yes, but this judgment, they have discussed.
Is it a conflicting judgment?
But they have discussed the finding of the Supreme Court in Nigamba judgment and all that. So by going through and in the first page, this judgment has taken care of all the aspect of the Supreme Court judgment. So this is basic correct view.
So we'll issue notice then.
Yes, Your Lordship.
Heard Mr. Roshan Subedi, learned counsel for the appellant, who submits that the appellant being aggrieved of the judgment and order dated 5/3/2025 passed by the Motor Accident Claims Tribunal ISOL, unanimous city case number 15 of 2021, has filed the instant appeal. Stop the learned counsel submits that the learned tribunal would not have awarded compensation to the respondent claimant in view of the fact that the driver of the vehicle who expired due to the accident was not the owner of the vehicle. Next para, in view of above, issue notice returnable by 3 weeks. Appellant to take steps for service of notice upon the respondents.
1 and 2.
Only one
1 and 2.
respondents by registered post with ADT within 3 days. List the matter again after 3 weeks.
I'm obliged.
Item 10.
No affidavit has been filed. Is it?
Yes, Your Lordship. I'm seeking another 2 weeks' time to file affidavit on behalf of state respondents number 1 to 6.
Anyone else besides 6?
There is no
7
private
is
respondent.
the
7 is there.
Private respondent.
Yes, Your
Is
Lordship.
notice is served
yes.
on respondent number 7. Parties are represented. Please write down. Parties are represented by the respective councils except for respondent number 7. Office note dated 22/4/2025 indicates that AD card has returned back from respondent number 7. Stop accordingly. Notice is accepted to be complete on respondent number 7. Stop Ms. Vanesyami, learned government advocate, appearing for the state respondents, praised for and is granted 3 weeks time. Further 3 weeks time to file counter affidavit.
Part 2, item 2.
Yes, anyone? Mr. Liam Shima is there.
Sorry, Lordship. We thought they were calling item number 3, Lordship.
Item 2, I think, yes.
Yes. So, my Lord, in this case, my Lord, if this, even though it's fixed today, my Lord, if this matter can be taken up on Monday, my Lord, next week.
My friend here, Mr. P.D. Nair, requested me to upgrade his, give him room for having hearing. He came all the way from Guwahati. His item is at item 4, I think.
Item 4, yes.
His client is still in jail, my lord, at criminal appeal. So ours, we can take up on Monday, since there is no urgency as such. If your lordship allows.
Okay. If there is no urgency, we'll list it week after that,
My lord.
16th. Weekly hearing list from 16th.
My lord, no problem.
Okay, as paid for by the learned councils for the parties, list this matter in the weekly hearing list commencing from 16th of June 2025. Item 2. Okay.
Obliged.
Item 3.
Please, Your Worship.
Yes.
This is an appeal under Section 37 of the Arbitration and Conciliation Act 1996 against the judgment and order dated 22nd of June 2023 passed by the Additional District Judge in arbitration case number 3 of 2022, where the award passed by the arbitrator was challenged by the respondents under an application under Section 34. And the award passed by the arbitrator was set aside by the Additional District Judge under Section 34, saying that the award was not sustainable because basically the dispute raised by the present appellant before the arbitrator could not be raised before the arbitrator. It was beyond the terms of reference of the agreement executed between the present respondents and the appellants. The appellant is the Association of Shop Owners in the Millennium Center. They are the Millennium Center Shop Owners Association. And they are, we can say, they are leases of shops in the Millennium Center, and they have executed lease agreements with the respondents. And the relevant clauses of the lease agreement, Your Worship, if I may take Your Lordship to page 12.
Paper book.
Paper book.
Mahat, you may go.
Page 12 of the paper book is the lease agreement. This is just one of the lease agreements executed between one of the shopkeepers as well as the respondents. And these lease agreements are basically for 91 years, Your Worship. And if I may take Your Lordship to clause 3, which is at page 13, this is the relevant clause.
Mr. Malhotra, before you begin,
Yes.
how long should it take, this matter?
Oh, this will take some time, Your Worship.
It will take time. This afternoon, I might have some difficulty in sitting. That's why.
It's up to my learned senior friend, Your Worship.
We have no objection, my lord. Some other date may be fixed, some other day, my lord. Matter we kept that part that, my lord. Matter maybe.
Not partner.
Otherwise, my lord.
It's a very risky thing, partner.
It's a convenient day.
Some date, certain date.
Don't fix it at the end of the week. It should be somewhere in the beginning so that if it spills over,
Yes.
at least you can complete the next day or the day after like that.
1st of July or
1st of July.
or
Anyway, we can try.
1st of July.
yes, ma'am.
It's a Tuesday. 1st of July is a Tuesday. Steno. Okay.
Your Worship, Your Worship, I don't think it'll be convenient because 1st of July to 4th of July, Honorable Justice Marley Wankung will be sitting singly. I mean,
Singly.
There's no one else.
Okay.
Okay. Then after review,
After vacation.
You want it before that or after that?
Anytime. My learned
After
my
that,
learned friend is coming from Guwahati,
After
so any convenient time for
14th? Monday? I think the calendar is there or not?
Yes.
yes, calendar.
14 or 15, any day.
14, okay. Please write down item, this is that same item number 3, hearing. As paid for by the learned counsels for the parties, list this matter for hearing on 14th of July, 2025.
14 July.
Yes.
14 July.
Item 4.
Mr. Nair,
My-
this matter, can it spill over tomorrow or
My lord, my lord,
this afternoon, maybe slight difficult?
my lord, my lord, my lord.
What is this matter?
My lord, it's against a conviction and sentence. My lord, convicting me for imprisonment, my lord, under the PC,
Under PC Act.
PC Act as well as IPC.
Okay. How many years?
My lord, 5 years.
5 years. And since when?
My lord, 2023.
23 only.
23.
Were you on bail prior
No,
to
my
that?
lord, I'm not on.
You were not on bail.
I'm not on bail. But
No, prior to your conviction.
prior to the conviction, I was on interim bail, and thereafter there's an allegation that I absconded. That is, after the interim bail, I did not appear, my lord. So if the case proceeded against me, my lord, it was split up. My lord, I'll be on certain technicalities, my lord. First and foremost, my lord, the witnesses who were examined, there are a lot of prosecution witnesses, my lord.
How many of them?
My lord, total, my lord, 39 prosecution witnesses. But, my lord, prosecution witnesses 1 to 35, 37 to 39. All of them, my lord, they were their depositions were taken without recording any order under section 299 of the CRPC. Since I was not present there, my lord, there are certain judgments to that effect. It is only the IO, who is prosecution witness number 36, who has been recalled and examined in my presence. So therefore, my lord, the depositions of all the other prosecution witnesses cannot be relied on at all, my lord. There's a specific judgment to that effect, my lord,
Without recording an order
under section 299 of the CRPC.
what is that?
My lord, 299 says, my lord, if a trial proceeds against an absconder, my lord, then, my lord, the depositions can be recorded in his absence, but they need not be recalled under certain circumstances. First, it is death of that witness. Second, the witness is incapable of deposing. Fourth, third, my lord, if it causes undue delay, expenses, or any situation which is unreasonable, my lord, for recording of witness or of his deposition. Only in those circumstances can the witness not be re-examined in presence of the absconder accused.
Appellant had absconded.
Yes, my lord.
Then how was he caught again?
My lord, he was arrested after conviction of the main accused.
Okay.
And,
And the evidence which was recorded
my lord,
in his absence
my lord,
have been relied upon.
they have been relied upon by the learned trial court, my lord. But, my lord,
So you are basically on the technicality.
not only that, my lord, this is the main part of my argument, that on this technicality, the witnesses, the depositions of the other witnesses cannot be gone into.
Who was recalled? Only the IO.
Only the IO. And the IO says he has not investigated.
IO is PW.
36, my lord. It is only the deposition of PW 36 which needs to be gone into.
He says that he is not the IO.
No, he's the IO, but he has not investigated major aspects. If my lord comes to the deposition of
There are more than one IO.
only one IO,
Then
my lord, he has not investigated it properly. That is why. Because there were certain allegations of payment of money from my account to the accounts of the architect and other consultant. That aspect has not been investigated. So, my lord,
So 299 says that
my,
it can proceed to examine witnesses,
yes, my lord. There are-
provided some orders recorded.
There is no order recorded. I have checked the trial court records, my lord. It is there in connected criminal appeal number 2 of 2023. In this, I have checked the trial court records here, my lord, in this file. It is not there. But in the other criminal appeal, it is there, my lord.
So if it's not recorded, then what happens? It vitiates
My lord,
the conviction.
it is not admissible, my lord.
You have that judgment?
Yes, my lord.
Sure.
My lord, I have given a list of books, my lord. My lord, 2009 7 SCC 104.
2009,
7 SCC 104.
paragraph.
My lord, many paragraphs here, my lord. From the facts of this, my lord, are in paragraphs 2 to 5, my lord, are the facts. Then, my lord, paragraphs 18, 23, 24, 25, 26, 30, 35, 38, 49, 53, and 58. Here it was, if my lord comes to paragraphs 2 to 4, paragraph 2, my lord, a proclamation was issued. In my case, there is no proclamation. My lord, may I read, my lord?
Yes.
My lord. Paragraph 2, the said question arises from the following fact situation. One Suresh Narsin Dubey was shot dead at Nalsapara railway station in the suburbs of Mumbai on 9/10/1989. The impleaded respondent herein, the brother of deceased, filed a complaint petition with regard to the incident. Appellant absconded. A proclamation under section 82 of the code was thereafter issued on 9/2/1993 declaring the appellant as a proclaimed offender. Subsequently, the said proclamation was also published in different newspapers on various states. In this connection with the said occurrence, initially 12 persons were charge sheeted upon completion of investigation on 27/8/93, wherein 8 persons, including the appellant, were shown to be absconding. Appellant and other accused were also booked under TADA. Indisputably, in connection with the case arising out of FIR number so-and-so, appellant was arrested in Delhi on 23/7/93 by letter dated so-and-so. Now, my lord, may come to para 4. Appellant was arrested by Maharashtra Police on 23/10/93 in connection with FIR number 3 of 92 and produced before Chief Judicial Magistrate Thane on 24/10/93 and was remanded to police custody so-and-so. Last sentence, he was in judicial custody till 21/12/93. On special leave petitions, criminal having been filed by the court, appellant and others, this court, by order dated 23/11/93, inter alia, directed splitting up of the case with regard to the absconding accused. Charges in the matter were framed by the designated judge on 30/12/93 on an application filed by the public prosecutor under section 299 of the code. An order was passed by the designated judge on 1/1/94. My lord, in this case, there was no application filed by the public prosecutor for recording of evidence under section 299. My lord. The stated paragraph 6, lordship may skip. Then lordship may come to paragraph 18. My lord, the right of an accused to watch the prosecution witnesses deposing before a court of law indisputably is a valuable right. The Sixth Amendment of the United States Constitution, so my lord may skip this, the extracted portion. We may, however, notice that such a right has not yet been accepted as a fundamental right within the meaning of Article 21 of the Constitution of India by Indian courts. In the absence of such an express provision in our Constitution, we have to proceed on a premise that such a right is only a statutory one. Then lordship may come to paragraph 23. An accused is, however, always entitled to a fair trial. He is also entitled to a speedy trial, but then he cannot interfere with the governmental priority to proceed with the trial, which would be defeated by conduct of the accused that prevents it from going forward. In such an event, several options are open to the courts. What, however, is necessary is to maintain judicial dignity and decorum. The question which arises for consideration is whether the same will take within its umbrage the said principle. We will examine the question a little later. We will proceed on the premise that for invocation of provisions of section 299 of the code, principle of natural justice is inbuilt in the right of an accused. A right to cross-examine a witness, apart from being a natural right, is a statutory right. Section 137 of the Evidence Act provides for examination in chief, cross-examination, and re-examination. Section 138 of the Evidence Act confers a right on an adverse party to cross-examine a witness who has been examined in chief, subject, of course, to expression of his desire to the said effect. But indisputably, such an opportunity is to be granted. An accused has not only a valuable right to represent himself, he also has a right to be informed thereabout. If an exception is to be carved out, the statute must say so expressly, or the same must be capable of being inferred by necessary implication. There are statutes like Extradition Act so and so. Then paragraph 25, it is beyond any cavil that the provisions of section 299 of the code must receive strict interpretation, and thus scrupulous compliance therewith is imperative in character. It is a well-known principle of interpretation of statute that any word defined in the statutory provision should ordinarily be given the same meaning while construing the other provisions thereof, where the same term has been used. Under Section 3 of the Evidence Act, like any other fact, the prosecution must prove by leading evidence, and a definite categorical finding must be arrived at by the court in regard to the fact required to be proved by a statute. Existence of an evidence is not enough, but application of mind by the court thereupon is, as also analysis of the materials and or appreciation thereof of the purpose of placing reliance upon part of the evidence, is imperative in character. Then paragraph 26, it extracts the order of the trial court. It says, keeping in view the aforementioned principles in mind, we may notice that at this stage an application filed by the prosecution on 1/1/94 and the order passed thereon on the same date, which are as follows. The application on behalf of the prosecution herein prays that the Honorable Court has framed charges against accused number 1 to 12 and absconding accused 1 to 3 on 30/12/93, and the case is postponed for hearing and recording of evidence of the witnesses today. That is so and so. Evidence is to be laid against the accused 1 to 12 is also in respect of absconding accused 1 to 8. That it is proved that it has become necessary to record the evidence of the witnesses against the absconding accused in their absence. It is therefore prayed that the order may be passed to record evidence against the absconding accused 1 to 8 in their absence. Then the order passed. After splitting up the case with regard to the absconding accused as per directions of the Honorable Supreme Court, but its order dated so and so, in petitions number so and so, this court has proceeded with the present case and has framed charge against accused number 1 to 12. However, as these 12 accused have been charged along with the absconding accused as shown in the charge sheet, the prosecution can adduce evidence relating to absconding accused so far as relevant to the charge and decision of the case. 8 accused have been shown as absconding accused. As the absconding accused are not before the court, the question of their identity will also arise, and it will be necessary to give them an opportunity to cross-examine the witnesses. Therefore, it would not be just and proper to use the evidence to be recorded in the present case against the absconding accused, and the evidence will be required to be recorded separately as to enable them to cross-examine the witnesses. However, if any deponent dies or become incapable of giving evidence, or cannot be found, or his presence cannot be procured without an amount of delay, expense, or inconvenience, which under circumstances of the case would be unreasonable, then evidence recorded in the matter may be used as per provisions of section 299 of the Criminal Procedure Code. The application having been filed by the special public prosecutor and the order having been passed on the same day, it is beyond any cavil that before the court, apart from the fact that proclamation under section 82 has been issued against the appellant, no other material was placed. Then Lordship may come to paragraph 30. Section 299 of the new code corresponds to section 512 of the old code, that is the 1898 code. The applicability of the aforementioned provisions came up for consideration before some high courts. We will notice a few of them. In my lord, from paragraph 32 to 34, my lord, the other judgments of the courts were discussed, my lord. And Lordship may come to paragraph 35. In Manbodh versus Emperor, Nazir Ahmed versus Emperor, and Rustam was followed. We must, however, notice that in Bhagwati versus Emperor, the Allahabad High Court held, the section nowhere says that the magistrate must record a finding. We wish to make it quite clear that in our opinion, the magistrate, before recording evidence under section 512, ought to be satisfied that the accused is absconding and that there is no immediate prospect of his arrest. and it is certainly advisable that he should recite in his order that he finds this to be the case. However, in this case, we find that the magistrate had clear evidence that the accused was absconding, and evidence from which the magistrate might reasonably infer that there was no immediate prospect of arrest. In his order, he expressly states that he is taking evidence under section 512. The presumption is that the magistrate did his duty and did not record the evidence under section 512 unlawfully. In our opinion, the mere fact that the learned magistrate did not recite a finding that there was no immediate prospect of arrest of the accused does not render the evidence inadmissible. We, with utmost respect, do not agree. There is no such presumption in law. An order of that nature must exhibit total application of mind. A judicious approach is imperative. For the said purpose, courts must bear in mind that an accused has a fundamental right as also human right. The term proved, having been used in this section providing for an exception to the general rule, was required to be strictly construed. It is not an ipse dixit of the magistrate that would be sufficient for attracting an extraordinary provision. The magistrate was required to apply his mind to arrive at a definitive finding on the basis of materials on record, in the absence whereof the order must be held to be arbitrary and thus without jurisdiction. Then Lordship may come to para 38.
This again speaks about
Yes,
Nirmal Singh's case.
Yes, my lord. This court in Nirmal Singh did not say, as was contended by Mr. Nafade, that Nafade was a PP, my lord, was on behalf of the PP, that non-compliance with section 299 would be an irregularity. What was considered to be an irregularity was non-recording of a statement the persons concerned were dead. In fact, the discussions on section 299 of the code and section 33 of the Evidence Act starts from para 4, wherein it was categorically held. Para 4, being an exception, it is necessary, therefore, that all the conditions prescribed must be strictly complied with. In other words, before recording the statement of witnesses produced by the prosecution, the court must be satisfied that the accused has absconded, or that there is no immediate prospect of arresting him as provided under the first part of section 299(1) of the Code of Criminal Procedure. In the case in hand, there is no grievance about non-compliance of any of the requirements of the first part of subsection 1 of section 299 CRPC. When the accused is arrested and put up for trial, if any such deposition of any witness is intended to be used as evidence against the accused in any trial, then the court must be satisfied that either the deponent is dead or incapable of giving evidence, or cannot be found, or his presence cannot be procured without an amount of delay, expense, or inconvenience, which would be unreasonable. The entire argument of Mr. Gopal Subramaniam appearing for the appellant is that any one of the circumstances which permits the prosecution to use the statements of such witnesses recorded under section 299(1) must be proved, and the court concerned must be satisfied that and record a conclusion thereon. In other words, like any other fact, it must first be proved by the prosecution that either the deponent is dead, or is incapable of giving evidence, or cannot be found, or his presence cannot be procured without any amount of delay, expense, or inconvenience, which under the circumstances would be unreasonable. In the case at hand, there is no order of the learned trial judge recording a conclusion that on materials he is satisfied that the persons who are examined by the magistrate under section 299(1) are dead, though according to the prosecution case, it is only after summons been issued, the process server having reported those persons to be dead, the former statements were tendered as evidence in the trial and marked as exhibit so and so. As has been stated earlier, since the law empowers the court to utilize such statements of persons whose statements were recorded in the absence of accused as an exception to normal principles embodied in section 33 of the Evidence Act, inasmuch as the accused has been denied the opportunity of cross-examining the witnesses, it is therefore necessary that the preconditions for utilizing such statements in evidence during trial must be established and proved like any other fact. There possibly cannot be any dispute with the proposition of law that for taking benefit of section 299 of the Code of Criminal Procedure, the conditions precedent therein must be duly established, and for the prosecution which proposes to utilize such statements as evidence in trial must therefore prove about the existence of the preconditions before tendering the evidence. Lordship may come to para 49.
Yes.
My lord, this is on waiver. An accused ordinarily would not be presumed to have waived his right. The procedural principles like estoppel or waiver would not be attracted where an order is passed without jurisdiction, as the same would be a nullity. An order which is a nullity cannot be brought into effect for invoking the principles of estoppel, waiver, or res judicata. Then para 53, my lord. We have proceeded on the basis that the right of confrontation is not a fundamental right, or whereby the accused's fundamental right has not been breached. Article 21, however, envisages a fair trial, a fair procedure, and a fair investigation. By reason of such right alone, the appellant was entitled not only to be informed about his fundamental right and statutory rights, but it was obligatory on part of the special public prosecutor to place on record the requisite materials before the learned designated judge to show that the appellant, after his arrest in Delhi case on so-and-so, was not an absconder, and thus provisions of section 299 of the code was not attracted. This, I'm relying on the first part, my lord. Then para 58, it relies on Antule, my lord. In A.R. Antule versus R.S. Nayak, this is the 1988 2 SCC, a 7-judge bench of this court has also held that an order which has been passed in violation of a fundamental right or in breach of the principles of natural justice, the same would be a nullity. So in this case, my lord, this is exactly what has happened. The trial court has relied on, my lord, the prosecution witnesses of 1 to 35 and 37 to 39, which it could not have done, and has violated section 299 of the Code of Criminal Procedure as well.
So thing was that you had absconded,
My lord,
and without there being any recording under 299,
my lord,
matter proceeded,
matter proceed.
and all these prosecution witnesses were examined.
My lord, my lord,
And later on, you surfaced again.
my lord.
And prior to that, the court case was, the main accused person was convicted.
Convicted, my lord.
So on that basis, the evidence of 1 to 35, 37 to 39 was relied upon.
My lord, my lord,
And accordingly, you were convicted.
my lord,
So non-recording of 299
my lord.
or the satisfaction of the court that it was not possible to wait for you, or because you are an absconder,
My lord.
would vitiate.
Would be and my lord,
Non-recalling of,
non-recalling of these prosecution witnesses.
okay,
To be
except for the
examined-
IO.
Except for the IO.
IO has been recalled.
IO has been recalled. So it is only the witness of the IO which is admissible. The other prosecution witnesses are not admissible.
Okay. Then,
This has also been relied, not only this one, my lord, other judgments, my lord, 2022 4 GLR 440,
2022
4 GLR 440,
paragraph,
paragraph, my lord, 35 and 37. Facts are in paragraph 5. Yes. Facts are in paragraph 5. This is also an absconding accused. Paragraph 5, my lord.
yes, please read.
Upon completion of investigation, the IO has submitted charge sheet against the 3 accused, namely Dinesh Guhai, Pandit Guhai, and Pushpadhar Borua under the provisions of section so-and-so of IPC. However, it appears from the record that the 2 accused persons, namely Dinesh Guhai and Pushpadhar Borua, went absconding, as a result of which the 3rd accused, Pandit Guhai, was alone subjected to trial. On conclusion of trial of Pandit Guhai, the learned trial court had reached a conclusion that the prosecution has failed to prove the charge brought against him beyond any reasonable doubt. As such, a judgment dated so-and-so, accused Pandit Guhai was acquitted. Appellant Dinesh Guhai was re-arrested by the police on 2010-2012, and fresh charge was framed against him on 3/10/2012 under section so-and-so IPC. Thereafter, the appellant was subjected to trial, which commenced on 7/11/12. It is, however, not clear from the record as to the fate of accused Pushpadhar Borua so-and-so. Now, my lord, may come to para 35. This is of a division bench of our court.
Yes.
Insofar as the arguments of the learned APP regarding applicability of section 299 of the CRPC is concerned, we find that the learned trial court has not cited any reason as to why attendance of the witnesses could not be secured during the trial of the case who are accused Dinesh Guhai. Moreover, statement of the witnesses recorded under section 164 CRPC has been exhibited so as to overcome the absence of the witnesses. In our view, such a recourse was impermissible under section 299 of the CRPC, read with section 33 of the Evidence Act, more so without recording proper reason as to why the presence of the witnesses could not be secured by the court below. Then para 37, It's an observation, my lord. Before parting the records, we deem it appropriate to observe therein that after going through the materials available on record, we find that it is yet another case of botched up investigation and flawed trial, as a result of which the guilty has gone unpunished.
And apart from 299, what is there?
My lord, Bankers Book of Evidence Act, Bankers Book Evidence Act, my lord, and my lord, the 65B of the IT Act. They were also not followed. My lord, there is no certification. I have seen that there is one Bankers Books certificate, my lord, but it does not mention the account number. So therefore, that also cannot be relied on. Which account number is being referred to? That is not clear from the certificate. So that part, there was another two judgments. My lord, in one of the paragraphs, it was mentioned that none of the high courts have held that right to cross-examination is a fundamental right. My lord, I found a judgment of the Jammu and Kashmir High Court. Let me come to para 4. Bare perusal, it is section 138 of the Evidence Act is extracted in para 3. Then bare perusal of this section, it is evident that after examination in chief, cross-examination is to be conducted if other party so desires. In criminal administration of justice, the right to cross-examine the witness by counsel for the accused is a fundamental right. The main purpose of cross-examination are to elicit favorable facts from witnesses or to impeach the credibility of the testifying witness to lessen the weight of unfavorable testimony. Cross-examination frequently produces critical evidence in trials, especially if a witness contradicts previous testimony. Further, in heinous offenses, so and so on.
This again is in respect of this 299 only.
299.
Because all these witnesses were examined.
My lord.
You did not have the chance to cross-examine
My lord.
since they were not recalled.
My lord. This judgment I'm relying on because Jammu and Kashmir High Court says that right to cross-examination is a fundamental right. It was against the observation of the Supreme Court because the Supreme Court judgment was prior in time, my lord. It says none of the high courts have held it, none of our courts have held it to be a fundamental right. So here there's one judgment. There are other judgments as well.
All right. We'll do one thing. We'll continue tomorrow.
My
Ms. Banasyami, you are there in this case. I think no order is required. This is in the hearing list. Okay.
Deeply.